But this really putting the blame on counsel, I mean, if counsel doesn't argue properly or whatever, even if we accept that, there are two punishments. We are going into punishments.
Yes.
The person may not insist on it because he may think I've got such a ironclad case. Why should I seek for lesser punishment? That would involve, in a way, admission on my part that it's applicable. And very well the counsel may not take that thing, but it doesn't mean that the judge should not consider it. That's a different thing altogether. So as perfectly as tactical ploy, but counsel will say absolutely not. I'm not interested in lesser punishment. I want a clean acquittal. So why should that be held against counsel or the accused? I don't see the logic of this argument.
But my lord, the only explanation on the transcript of this interview, I am not aware whether otherwise there was one, is that he says कि उसने हमें एक किस्म का नाराज कर दिया था.
हाँ, वो बात आप कह सकते हैं.
जी.
नाराज कर दिया तो या सुनना छोड़ दें या फिर भी इंसाफ करें.
And in his,
हम भी नाराज हो जाते हैं कभी. ये तो मतलब नहीं कि फैसला उलट दें. कभी कभी वकील की सजा उसको तो ना मिले ना मोकल को.
सब ये अपील में उन्होंने अल्टरनेटली मिटिगेशन के बारे में कहा है या नहीं कहा? ये तो ये कह रहे हैं ना कि हमारे सामने नहीं कहा. अपील में नॉर्मली एडवोकेट जो हैं वो एक अल्टरनेट रेमेडी लेते हैं, तो क्या वहाँ मिटिगेशन के बारे में कुछ कहा गया कि ये नहीं हो सकता?
Sir, it appears from Mr. Justice Durab Patel's judgment in the review note that this was an argument made for the first time in the review petition.
नहीं, मेन माय लॉर्ड पूछ रहे हैं कि मेन जो जजमेंट था
अपील में क्या लिखा?
In the review it appears that they refused to look at it on the ground that this was not a submission made in the main appeal. So the review judgment suggests that this submission was not perhaps made in the main appeal.
सबमिशन करना समथिंग else.
जी.
क्वेश्चन रहते जब भी अपील लिखी जाती है
जी सर,
तो उसमें एक अल्टरनेटली ये कहा जाता है कि इट्स नॉट एक्सेप्टेड केस फॉर कैपिटल पनिशमेंट. उसके मिटिगेशन के सर्कमस्टांसेस बता दिए जाते हैं. मैं वो कहता कि अपील में तो ऐसा है, ये तो कहते हैं हमारे पास सबमिट नहीं किया, वो तो कहे, लेकिन उसमें है या नहीं है, बस ये क्वेश्चन.
Lord, in so far as I am aware, no.
Makhdum sahab, such like submission pleas are made in the submissions before the court. Alternate remedies asked from in the court.
Yes, yes.
उसमें लिख नहीं देते बिकॉज सारा केस फिर उधर चला जाता है कि अल्टरनेट रेमेडी.
क्रिमिनल अपीलें आप देखें 4 लाइनें की तो लिखते हैं, कुछ लिखते ही नहीं उसमें, unlike civil pleadings. But the fact remains that the judge has to consider it. If a lawyer doesn't take this plea, actually we do the whole thing very lopsided in Pakistan because every criminal case has two components which we tend to overlook. One is conviction and one is sentence. I mean, in the West, you have a separate date of hearing of matters for sentencing. Then that person then pleads, these are the mitigating factors. Here we roll it all up into one. And this is the duty. I don't think it's a duty, even if the counsel doesn't take it, wherever it's the duty of the judge to see if mitigation is there. Because then you err on the side of caution and you give the lesser sentence as opposed to maximum one. And then you have to justify the maximum one because it was a horrendous crime or whatever you want to say. So that's the general way it should happen. Otherwise, criminal appeals don't say much. I mean, if you read criminal bail applications, they don't say anything.
Sir, I have never read it myself, but I have heard from senior members of the bar, some of them are no more, that one of the most celebrated criminal appeal lawyer before the Lahore High Court, West Pakistan High Court at that time, was the late Mr. M. Salim, whose entire murder appeal used to consist of one sentence: the judgment of the trial court is opposed to the facts of the case and contrary to law. And M. Salim.
Yeah, we also see the same pattern still.
Because it's a first appeal and all the facts and the law have to be examined by the High Court, so there's no point in going through it, and that's how it was done. There was a printed form, I'm told, of the Lahore High Court, and he would add only one sentence.
Is this the only case where the High Court had heard a case of murder as a court of first instance?
My lord, in Pakistan,
is there any other precedent? I'm not aware.
There may have been other, but in reported judgments in Pakistan, I have not come across. But that may be on account of
We just raised this question. Maybe some other counsel can also address it. Whether this was the one and only case of its kind which was heard by the High Court, because I'm more looking at the totality of the matter as opposed to individual things.
Yes, my lord.
Martial law, High Court trial, one right of appeal lost. You saw all these factors, 3-2 split decision. I don't know of any other, and is there any other case which has been, you've given capital punishment on a split decision? These are all these other factors which come into play. Then, as my lord observed, that some of the judges were persecuted.
And Justice Durab Patel, when your lordship summoned that transcript from PTV, says that in a split decision like this, it doesn't happen. He says that even in his review, very short.
Even if he doesn't say it, that's a general principle of law.
Even in the review judgment, my lord, which is a one-page judgment where he concurs with the majority, but he says that this is a point which has been highlighted, and from India a judgment has been produced where the split was 2-1.
But unfortunately, he was part of the review of a unanimous review.
Yes, my lord. But
that is what's troublesome also. All 7 were unanimous on the review.
My lord, but if your lordship reads the review judgment of review opinion of Mr. Justice Durab Patel, there's a very short opinion, about a page and a half.
I've read it.
Yes, my lord, it says very simply why he's there. He said Mr. Yahya Bakhtiar has argued.
He's put all the blame on the counsel.
No. He says 2 things, my lord. He also says that while arguing this case, he has been unable to persuade the majority to change its mind. So the outcome remains unaffected. And
the outcome to sentence doesn't remain unaffected. There can be the capital punishment, or there can be imprisonment for life.
On that, my lord,
I think basically determining factor is it the duty of the judge or is it the duty of the counsel? In my opinion, it's the duty of the judge to look at it.
On that, his view is, with which Mr. Justice Ghulam Safdar Shah and Mr. Justice Muhammad Halim agree, that this is raised for the first time in review, and he mentions that and he moves on. But his basic thrust of his reasoning appears to be that you have failed to persuade the majority, so if we just reiterate our views earlier expressed in dissent, where would that lead to? The judgment would stand.
I'll just tell you a simple thing. This is a criminal appeal.
Yes, ma'am.
What are you saying? Set aside the judgment. Basically, you're saying that in a criminal appeal. You're not saying, let the judgment hold, but give me a lesser sentence. I mean, you're not really saying that in a criminal appeal. That's only a matter of law, settled law, whether you will grant a lesser sentence or not. For the judges, with the greatest respect, to say that it was not argued before us, I don't think that is probably correct approach, because we always look to mitigation, whenever I've heard of cases, whether it's argued or not.
My lord, correct.
Unless it's a case where already the lesser sentence has been given. Then the burden shifts. Then the state or the complainant may come for enhancement of sentence. There the burden he has to plead. That I'm standing by the judgment, but please enhance it. There was no justification for giving the lesser sentence. That would be altogether a different category of case for enhancement. This, you are here, if he said precedent, I don't know of any other court which has followed this precedent, that it's for the counsel to plead lesser sentence. If we uphold the judgment, why should he do it?
Outside, as your lordship observed, it's different because the judge.
In Pakistan, we're talking about.
Because over there, my lord, the judge of facts and.
Like I told you that there are 2 separate hearings altogether.
Yes, because the conviction is for the jury, and once the jury has convicted, then the sentencing is for the judge, and it's the sentencing stage that the plea of mitigation comes in.